Welcome back to Sunrise City. Well, we're actually going to be talking about the CJN's matter. You might have been following or heard several of them. So we've got Mr. Benson Enikome, who is a legal practitioner, and Mr. Biodun Israel, a member of the APC. Gentlemen, thank you for coming on this morning.
Thank you for having me.
Well, actually, the matter was supposed to continue today, but in context of all of these suits, the headlines we see, what's likely going to happen? Is the matter still going to come up today? What do you think?
I won't know what would happen, but I know what happened before now. What happened before now was that there was a positive order of the court that the CCT should not proceed with the arraignment of the CJN. And that positive order of court must be obeyed. Until it is set aside, anyone who does otherwise is in contempt of the court. So if the CCT feels that the order of the court is not what it should obey, it goes to confirm the seriousness we attach to judicial decision. And I think they lose absolutely nothing. I mean, the CCT lose absolutely nothing by obeying the positive order of the court, which was reinforced to the effect that the CJN should not be arraigned. Anything to the contrary would mean we have thrown the rule of law to the winds, and then it is the rule of might that is taking place.
What do you think?
Yeah, for me, I'm not a lawyer, but my take is that we are not serious as a country.
How?
To fix this country. We are not serious because we usually, most times, when it is time for us to take a leap of progress, we bring in ethnic cleavages, we bring in religious sentiments. That's why I said I'm not a lawyer. But the issue about the CJN, for me, borders on morality. If the infractions committed about the #1 law officer of a country and the office of the CJN raises a lot of questions than answers. So if the CCT will not arrange the CJN today because of the order of the court, fine and good. But does it remove the fact that the #1 law officer of a country is associated with such infractions? That, for me, should be the key issue for us to look at.
Because I'm wondering, after you've made your submissions, that the CCT, whatever it is that the court says it should do, should be binding.
Very well.
But it is the same case of the federal government against Nganjua that established that the NJC must preside over cases that has to do with judges' infractions. Where does that now stand?
Well, the truth of the matter is this. We, like my colleague said here, we are not a serious nation. And I say this cautiously and with greatest respect. When it pleases you, you canvass for sentiment. When it does not please you, you go for morality. When it pleases you, you go for law. The country, for goodness sake, is governed by law. We are not a banana republic. It is the law that those who feel they should arraign the CJN, it is the law they want to apply. And this same law has provided for the procedure by which this man can be tried. You mentioned the Nganjua case. It's laid down that before you arraign any judicial officer, before any court whatsoever, the NJC must look at the issue. It's a constitutional provision.
But is the NJC, in this case, having that moral jurisdiction, or should I say,
no.
let me land, having that jurisdiction, considering that the CJN himself, being a judge and also not an ordinary judge. He's the Chief Justice of Nigeria, even though he's still a civil servant. Number one, would it be morally right for him to be the CJN, knowing very well that out of the 23 members of the NJC, he appoints 20 of them? Wouldn't he be a judge in his own case if we have to go through the NJC?
No, we're getting it right. The CJN is a member of NJC and chairman.
Who appoints 20 members
No,
out of 23?
It did not. The CJN does not have the right to appoint anyone. The justices of the Supreme Court are appointed by the NJC, recommended to Mr. President. Mr. President sends the name to the National Assembly. The Senate will confirm. It is not an appointment by him. No. The point I'm making is this. When this matter comes before the NJC, the CJN steps aside in the decision. It's not going to sit on its matter.
What do you mean steps aside?
In other words, when NJC is to decide its matter, he must not be part of it. It is like a company, or maybe in an organization where you have an interest, and then a contract is brought and you have an interest in that contract. You don't participate. You withdraw yourself. The principle of nemo judice will apply, that you cannot be a judge in your court. So let the matter go before NJC. It is when the CJN says, I want to participate, that we'll be raising the issue. I know the man will not.
But, you know, is the failure of the CJN to declare some of his assets, as alleged, a misconduct within the scope of his duties that requires the matter to be brought before the NJC?
Now, the law is clear on this. Let's look at the Constitution. Section 292 of the Constitution provides for this. Under that section, it says, a judicial officer shall not be removed from his office or appointment before his age of retirement, except in the following circumstances. 1. In the case of the Chief Justice of Nigeria, President of the Court of Appeals, Chief Judge of the Federal High Court, Chief Judge of the High Court of the Federal Capital Territory, Abuja, Grand Cadi of the Sharia Court of Appeal of the Federal Capital Territory, Abuja, and President Customary Court of Appeal of the Federal Capital Territory, Abuja, by the President, acting on an address by 2/3 majority of the Senate, praying that he be so removed for his inability to discharge the function of his office or appointment, whether arising from infirmity of mind or body, or for misconduct or contravention of the code of conduct. First explanation. If the president feels that the man has contravened the code of conduct, one of the very first steps he can take is to approach the National Assembly, and by 2/3 majority, the Senate will say, remove him. That is the first procedure. Second one, in any case other than those to which paragraph A of this subsection applies, by the president, or as the case may be, the governor, section 2 rather, subsection 2. In any case other than those to which paragraph A of this subsection applies, by the president, or as the case may be, the governor, on the recommendation of the National Judicial Council, that the judicial officer be so removed for his inability to discharge the functions of his office or appointment, whether arising from infirmity of mind or body, or for misconduct or contravention of the code of conduct. Contravention, you are talking about contravention of the code of conduct. For you to go ahead and do so, the Constitution, which is the ground norm of the country, says, President, Governor, before you do it, go and talk to NJC.
But this borders on removal. But what the other issue now is, isn't this an inquiry into misconduct, not removal?
Now wait. And that is what the Ngajua case decided.
But if it borders on misconduct then, It doesn't go. It doesn't have to go to NJC.
No, just a moment. The Ngajua case, which is the law as at now, says before it's a judicial officer, before you unclothe him, before you remove that from him, you must first approach the. That is the law of the ground. Okay. Morality, good as it were, morality in this matter follows the law.
Let's hear hold on the morality.
Yeah. Did the Nganjua case against the federal government take into consideration a judge going on the trial? Did they consider that the judge may be above the status of a judge and being also a judge at the same time the CJN?
You know.
No. Did it consider that?
Just a moment. You know the reason why this is being done. It is only God that has power to judge. But it has given to some persons the authority to do so. Okay. When you want to remove...
Let's bring Mr. Abiodun. Pardon me. You will still talk about...
Okay.
Go ahead now.
You see, like I said in my opening remarks, I listened to Chief Robert Clark, the man who went to get the Gandua case in the Court of Appeal on Sunday on Politics Today on Channels Television. And he made a profound submission that for the CJN to be associated with this infraction in itself is a dent on the image of the judiciary. The fact that the #1 officer of a country is mentioned in this infraction at all calls for a lot of concern about the judiciary. That's number one. Number two, the alleged infractions. If the admission that we read, not yet confirmed by the CJN that he forgot, is it not morally bound? Like somebody said, if the person said his friend from Ghana called him and said, do you mean your CJN, a CJN of a country, can have that number of domiciliary accounts, and forgot to mention it in his code of conduct information? So the question we are saying, or we are asking, is that if there's an admission, like I said, not yet confirmed by the CJN that he forgot, is he not morally bound as a #1 law officer? Now let me close this submission by what Justice Chukwudibo
But there's no morality in the place of justice. No.
Gimba, you know the system. Question you raised, the question you asked, that if, and that is the valid position, the member of the NJC, I listened also to your former colleague here, Digi 360, on Sunday, where he highlighted the composition of the members of the NJC. Almost 90% of them are appointed by the CJN. That cannot be controverted. So if you now said, in any case, some lawyers will also tell you, like I listened to GT Ogunye, that most of the petitions that go to NJC, what comes out of it? So now for political exigencies, like Robert Clark concluded, maybe the government in their wisdom, because nobody will now say the Attorney General, the first law officer of the country, will not be aware. And that's why I said I'm not here to canvass the position of the law. But I'm saying in civilized climate, in a country where there is sanity, in a country where we follow the letter and the spirit, it's enough for the CJN to take a bow.
You know, they say in justice must not just be done.
It must be manifestly seen.
It must be seen to have been done. That speaks to perception. Isn't perception important in this particular case, as is highlighted?
Now, a number of things will get wrong. We model them together, and that will not be correct. Now, he who alleges must prove. An allegation has just been made against the CJN. It is not substantiated. Now, as soon as you raise an issue about a person, the person must leave. You know, Nigeria is a country that thrives on rumors. For example, If we allege, for example, now, that Mr. President has just taken 500 billion, and then immediately somebody alleges that, President should resign. Hey, I said we are not a serious nation. And I mean every bit of it.
Would that be a fair comparison?
I am talking about the truth.
Just
a moment. Allegations have been made against so many persons. Recall when allegation was made against Senate President, that the Senate President is, he didn't feel the code of conduct, he did bad, and then people came out with morality. When it suits them, they go to church for morality. When it suits the other way around, they go to law. I said morality follows the law. I am a person who believes in moral sanctity. But at the same time, you don't just come from the blues. I must look at what is the intent of government in this regard.
So what's the morality behind the CJN not allowing the process to go through the CCT?
Have you heard from the CJN now, by reason of his disposition, to say he didn't do A, he didn't do B? Somebody comes to say, oh, he wrote this, said he forgot. Do you know what transpired on the social media? Do you know how many stories?
Does morality have a place
just a moment.
Does morality
do you know how
have a
many
place in
stories
law?
go on social media that are unfounded?
Does morality have a place in law?
It does. Lord Denny, it does.
I'm surprised. My friend said he's not a lawyer, but now he comes to say, but I have put in with greatest respect some 25 years in this profession. So I know what I'm talking about.
No, but in the question of perception, just as it's highlighted,
yes,
the fact that, look, if the CJN, according to from what he said, is associated with this, for those who are watching...
By the allegation, by those who allege it.
But he also went ahead and said, look, he admitted that he didn't submit the
Just
form.
a moment. Have you confirmed that from the CJN?
Are you saying that's an allegation or another allegation?
Just a moment. Have you confirmed that statement that, oh, it was an error by me? Have you confirmed from him? Have you found out?
Sorry,
we have had no, hold on.
Just a moment.
Let me clarify on that.
Oh.
We have had it on record in this station when we read it on the news.
Yes.
The first day it broke, the CJN's response was that
it was his response.
It was those accounts he forgot to mention.
Clearly.
What will be your interpretation? What will be your interpretation of that?
Now,
it's an admission.
Just a moment. That you forget something in law, or that there is or you didn't remember, is not an excuse, as it were. The law will not say I'm ignorant of it and do an excuse for it. But again, in doing that, there is a procedure you must follow.
Okay, let's
talk
about
procedure. If you do not follow it, everything will be granted. As soon as government became aware of this particular thing, the step they ought to have taken was to have written to NJC. We noticed this.
But part of the functions of the CCB, 3D says, one of the functions is that the CCB would receive complaints about non-compliance with or breach of this act, and where the Bureau considers it necessary to do so, refer such complaints to the Code of Conduct Tribunal.
That's correct.
Established by Section 20 of this Act in accordance with the provisions of Sections 20 to 25 of the same Act. Yes. How does that differ?
When it relates to judicial officer, from what I've read, just a moment, that particular section will be interpreted subject to what is written in the Constitution Section 290. Just hold on. Section 292, subsection 2. When it relates to judicial officers, before you do that, you send to NJC. When NJC derobes him, when NJC derobes him of that, you try him.
But when the NJC derobes him, he stops being a public officer. Because according to Professor Isesage, please hold on. According to Professor Isesage, it says, if he is removed from office by the NJC and he ceases to be a judicial officer, he also ceases to be a public officer. Consequently, he cannot be tried by CCT.
Just a moment. That is not true. Professor Sage, with greatest respect to him, that position is wobbled. And I will say this. You commit a crime, and then you are derobed of your position. Does that mean that the law will not catch up with you?
In which court?
Just a moment. In the CCT, as it were, those governors who left office as governors, are they not being tried? Does that mean that as soon as they left the office of the governor and then they are brought before CCT, it will no longer be applicable? I think we should be reasoning in manner that will.
Okay.
Listen,
let me ask you this one. Let me ask you this one, sir. Which one comes first in the case of the CJN? Is he first of all a judicial officer or a public officer?
The CJN is a judicial officer.
He is a judicial officer, yes.
He's a judicial officer.
Who employs him into judicial office, the NJC or the public service?
The NJC.
So you are saying that the NJC takes precedence over the civil service?
For goodness sake, you can't classify the what do you call it, the CJN as a civil servant.
How does he differ? How does he differ from the Senate president?
Just a moment. There are 3 arms of government.
Okay.
The legislature, the judiciary, and the executive. Under the executive, we have the civil servant.
Mr. You seem to disagree.
Yes, I do. Because just like he's asking, if the NJC is the one that employs the CJN, does he remove the fact that he's not a public officer? As a number 1 law officer? So that is the position. And like Gimbia asks,
there's a distinction between law officer and judicial officer.
Like Gimbia asks, the same, and like GT Ogunye also submitted, if there is a misconduct as a judicial officer, then you refer the matter to the NJC. Not an infraction of a criminal offense based on what he read out about the function of the CCT. So if you now, like Gimba affirm, that you confirm the position of the CJN to have forgotten, I mean, that's why I said we are not serious. In a civilized clime, you throw in the towel. If a judicial officer, number 1 law officer of a country said, I forgot to mention those domiciliary accounts, which is a specific legal requirement for somebody occupying the office of the position of the Chief Justice of Nigeria.
But going by the law that made up the CCT, isn't it easy for us to infer that the CCT actually is a product of the National Judicial Council? Because according to Section 20, subsection 4 of the Act that created CCT, says the chairman and other members of the tribunal shall be appointed by the president on the recommendation of the National Judicial Council. Yes. So by this we can infer that the CTC is a product of the NJC.
Now you have made my job easier. Those persons were not appointed by the president suo motu on his own.
Agreed.
Listen, he had to go to NJC to get the recommendation. The president, with greater respect to him, is not competent to appoint anyone in that capacity if NJC does not stand on it.
Agreed.
Hold on. In the same token, the president also cannot go ahead to discipline any of them if NJC has not so advised.
All right, we'll come back to this in the moment.
You made my job easier.
Why'd you have to make his job easier? We're back in a moment. Stay with us. Welcome back. Well, this is our concluding moment for this segment. And gentlemen, let me even attempt to take a step back and look at the system and the structure in terms of how some of these things are working for perhaps posterity and for future purposes. I'm just wondering because you quoted a number of people who have spoken on this matter saying, look, ordinarily, if he's associated with this matter, it's a disgrace, it shouldn't be, it should be heard for the judiciary. But on the flip side of it, what if he's able to clear himself and explain how all of these things matter, how he came about all of these things? Will he be able to get his name back?
Well, for me, that again is subjective. It's subjective in the sense that, look, we have had brilliant judges. The late Justice Kayode Esho, Chukwudifu Oputa, exemplary people who have occupied position of influence. And the fact that you are a judge, and that's why I said, I will quote what Chukwudifu Oputa said at the Oputa panel, that if a country has a set of judges who occupy the apex courts, meaning the Supreme Court, and that country apex court jurists can now be bribed, then that means that country.
Well, assuming this, but this is we're not sure. This is not a bribe.
No, I'm just quoting him.
Yeah.
So what I'm saying in essence is that yes, the CJN can go to CCT, but now there are not another dimension to it, like Mr. Valano said, SAN, is that there is a barrage of applications in courts. But so industrial court, this one court, restrain, stop this, stop that, you know?
Well, lawyers will do their thing. But, you know, the other question about that is this. Because, I mean, speaking to a number of lawyers, you know, behind the scenes, some of them think that there's a yearly external medical treatment budget for some of these officers. They say there's one for the president, the vice president, permanent secretaries, of which the CJN benefits from. And so and they all receive them in foreign currency. That's why they're obstacles.
Chamberlain, nobody is questioning.
Yeah, but I'm just looking at posterity.
No, that's what I'm saying. Nobody is saying the CJN cannot have such money. Did you declare it? That's the point. You have such, okay, you have from this source, from medical, from this, the total is XYZ. Was it mentioned?
So let me ask you this.
You need to respond to this.
Oh, okay.
Now, the point is this. We are to come into this studio. There is a route by which we come into this studio. You can't jump through the roof. If you jump through the roof, it's either you meant harm for the people that are in this studio. For all that have been said, the law is clear. When you are to do this, petition NJC. Go through that process. You want a man...
That's the controversial point.
That's exactly... Yes.
For now, the law is simple.
Yeah, but
why are lawyers quarreling over this same thing? It's not something that we are doing in the civil society.
Lawyers must quarrel over because, one, we will not reason in the same way. Somebody will reason because of the interest he has.
But they are all quoting the same law.
But the point is that, as of today, the law in Nigeria about whether a judge or a CJN can go to CCT has been laid down in Ngajua's case. You must go to
Ngajua's case is a function of misconduct as a judicial officer.
Yes.
This one is not in the course of duty as a judicial officer.
Yes, that's the difference.
Sir, did you read the section 292 I read to you?
Yes.
That when it even involves infraction to CCT, that you must go to NJC. Read it, section 292, subsection 2.
But it's the same law.
How does it sound? Going to the NJC, knowing fully well that the chairman of the NJC is the CJN.
He will withdraw once the letter
does the withdrawal remove the fact that...
So has he withdrawn?
No, the point, have you taken any letter to NJC? There's no letter before NJC.
Give back.
So
there's no petition against him to NJC.
What then must be done at this point?
Let the government do the needful. Let them write to NJC.
Greenback, granted that...
Let them write to NJC.
Granted that...
Let's get
granted that he can recluse himself as the CJN when the petition gets to the NJC. Does he remove the fact that the larger percentage of the people in that NJC is appointed by...
No, but that's the principle of natural justice. That he can...
Does he remove that fact?
No, but it has happened in courts. If the lawyer writes, you can always recuse yourself.
Now, wait.
Does he remove that fact?
I'm a little bit worried. It means that we have turned all our justices and judges to robots. By reason that a petition is brought against the Chief Justice of Nigeria, then all other judges will follow suit, and they won't reason well.
Let's get both of you.
Let's not throw our judiciary into that mess.
Let's get both of you to weigh in on this.
I don't want to say what the Chief Robert Clark finally
Robert Clark is a senior advocate of Nigeria to whom we give a lot of respect.
Because he made a profound statement on Sunday.
But the truth of the matter is, the profound statement made by Chief Robert Clark is at best, with greatest respect to him, not the judgment of the land.
There you go. You know, lawyers will always have a